Chief, I beg to mention item number 9, my lord. 9, 10 and 11. These matters are those Nehu matters, my lord. This may come up after 3 weeks, my lord. Because the other matter is not yet decided.
Have you sought consent from the...
My lord, I have not informed. I informed them. Otherwise, my lord, the main matter is not yet decided. So
even then, I was thinking, we'll continue with the hearing, irrespective of you, because the other matter, we don't know when the judgment will be ready. So if we keep on waiting, it will not be proper.
On the next date, my lord, take it up.
But at least you should have informed the council.
I'll inform them, my lord. Now, right now.
They may agree, they may not agree.
No, then let it come up.
Let it come.
My,
In the meantime, you inform them.
my,
This item 19 and 20, my lord. I've just printed the orders of the matters in Supreme Court. This is those enforcement inspector matters, my lord. Lord, the first order, my lord, is dated, I've marked, highlighted order dated 26th August 2022. This was when, my lord, and the next page, notice was issued. This is our matters, my lord. Then the next order, my lord, this is dated 8th of August 2023, recently. The last line, my lord, registry to process the matter for listing before the Honorable Court as per rules. So we are waiting for the matters to be listed. Now what is important is, my lord, the last order. This is, my lord, dated 28th August 2023. This is SLP filed by the state. Kindly have the cause title, my lord. So the state's SLP has been tagged along with us. So, my lord, we are sailing on the same boat as far as that matter is concerned. So, my lord, last time, on the last occasion, Mr. Shulai was saying that, we want to proceed with this matter. So, we have to be clear. If we are sailing on the same boat, then, my lord, perhaps we should be waiting for something. Because if the matter is listed, then it may be admitted, maybe not, my lord.
So, the same order was impugned?
Yes, my lord. Same order, as private parties, we have challenged, and the state government has challenged. And as far as those original petitioners is concerned, my lord, they have not entered appearance. They have not filed any counter also. So we don't know what the fate will be, my lord, but it says as per rules, be listed.
This is 2021 matter.
Yes, my lord.
By the time it comes back, it could be 2025, 26, 27. For all we know.
My lord, it's yet to be admitted. We really don't know. Our SLP might be dismissed also. We don't know. So if the SLPs are dismissed, then my stand will change a little bit, because the petitioners in these petitions, we are qualified to be appointed by promotion in terms of seniority also.
But is there an impediment, on account of the order, assailed before the Supreme Court?
The reason being, we have already served 8 years in that post of Assistant Enforcement Inspector, which was nullified by your lordships in your lordships order. So that 8 years is very important. Tomorrow, if we succeed,
seniority is concerned.
promotion to these posts, Enforcement Inspector.
By seniority.
So if we succeed, then the 8 years which we have served in the post below, Assistant Enforcement Inspector, that will be counted as qualifying service to be promoted. So that is why we don't want these posts to be filled by direct recruitment, because we are entitled as per promotion. So let it come up after 6 weeks.
Mr. Piraman Nongri, counsel for the petitioners, has submitted that the matter before the Honorable Supreme Court is due to be heard. Which do be heard, the outcome of which will have a bearing on the issue raised in these petitions. It is prayed that this matter may be adjourned for the time being. As prayed for, this is matter of the 6 weeks.
Obliged, Your Lordship.
So that's 19 and
20.
20.
May it please Your Lordship, I beg to mention item number 14. Your Lordship, I pray for 2 weeks' time in this matter, my lord.
This is only for your reply to be given.
This 21. Similar prayer for item number 21 as well.
So 14 and 21 are connected. The issue of maintainability has been raised,
Yes, Lordship.
and matter has been. I believe the petitioner has been heard.
Yes. Written synopsis.
No, 14 has been heard.
Not yet.
But here also in 14 also issue of maintainability has been raised.
I believe so, my lord, by the respondents. The main
Yes, the main respondent.
Mainly, Lordship, in item number 21, we were supposed to file the written synopsis.
You have filed.
Therefore, fine.
You file yours.
Therefore, fine.
Just to recollect, my lord, after your lordships had heard that item 21, and when the turn of item 14 came, then it transpired that since item 14 is the 711 application, had we heard the 711, nothing would have survived to be heard.
Okay, okay.
Yes, ma'am. So that confusion was there. Yet,
So now we have to first dispose of the 14. Item 14.
21.
it's up to your lordship.
No,
because your
what do-
lordship is-
What would render, which case in infraction?
if 14 succeeds, my lord, everything goes.
So it stands to reason that the 14 has to be disposed of first. But we have gone the other way.
Because 21 is on an injunction.
Yes, of course, I remember that. Then we, we hear the item 14 and get it disposed, and then if it has a bearing on the, merits of item 21, then so be it. So 14, you are ready.
No,
You are
Lordship.
ready to be heard on 14.
14, Your Lordship. After 2 weeks, Your Lordship.
That is the difficulty. Because I think if the injunction goes, my lord, if the injunction goes, then also everything becomes fluctuous because the injunction is on the renewal of license which the government has not renewed. And they are surviving because of the injunction.
So, in the meantime, fresh license have been issued.
Not to them, my lord.
Not to them, but to you.
To me, who's a new party. So license it as on today, I am affected because that injunction, I am a licensee, and I am no more a licensee.
So your function is also in limbo now.
Yes, because of the injunction. I think it is better if your lordship decide 21 and we will see from there. Since it's already heard.
There are counsel for the petitioner, for the respondent. Your respondent number
Respondent number
1
1, Your Lordship.
has sought for accommodation to be heard in this matter, as the learned counsel is not prepared to be heard today. On the same not being objected to by the petitioner, prayers allowed. This is matter to 2 weeks, as prayed for. How to 21 counsel has sought for some time. Learned counsel for the respondent 1 has sought for some time to file the written argument, which could not be filed today. Let the same be filed within the next date fix. This is matter to 2 weeks. I can joke with date.
Much obliged, Your Lordship.
Please, Lordship. Lordship, I beg to make a mention for item 15.
15.
Yes, Lordship. Pray that matter may come up to 2 weeks, Lordship. 15.
I'm appearing on behalf of the respondent, Your Lordship.
What is the subject matter?
This is the suspension of the mining operation, Your Lordship. The Komara limestone. Lordship, as per the last order that the respondent
We were supposed to see instructions, Your Lordship. We're still waiting instruction in this matter, Your Lordship.
On pre-made by the parties. This is matter of
2 weeks, Lordship.
2 weeks.
Lordship, I have similar prayer for item 18, Your Lordship.
On pre-made by the petitioner. This is matter of 2 weeks.
Your Lordship, I'm appearing on behalf of respondent 1 and 124.
Hello, bless.
I think so.
Please, Your Lordship, I beg to mention item 17.
Why?
Lordship, I'm hoping that this matter may come after 1 week.
On pre-made by petitioner. This is matter of 1 week.
Lordship. Lordship, I beg to mention for an unlisted matter, my lord, for today.
What?
Here, my lord, what happened? My lord granted interim bail to my accused petitioner, and my lord, it is expiring today, and he is supposed to be, my lord, be present before the jail authorities tomorrow. And my lord, he is still under medication, Lordship, and doctor has advised him for further rest. So, my lord, if my lord may kindly take up the matter today, Lordship.
You should have come earlier.
We've already filed, my lord. The petition has been filed yesterday. And the difficulty, my lord, because of his weakness, my lord, the accused could not come, my lord. He just could come yesterday, Lordship.
The interim bill was
Lordship.
fine.
For item number 9, my lord, the other side is.
All these cases, my lord, depending on the judgment that is pending before your lordship.
Yes, but I was thinking that judgment. I don't know when it will be delivered. Could be soon, could be later. But the fact remains that I think we had agreed that we can hear this matter. Start at least the hearing and then.
Oh my lord, lordship, it was this same scheme was involved in all these cases. So lordship, our prayer was that lordship will take up one matter, and once the judgment is delivered, my lord, other things will follow.
But that was not the the contention of the petitioner.
No, my lord,
If I remember correctly, it was said that the facts more or less may be the same, but the issues
But, my prayer will be, my lord, let the judgment come, my lord, things will be easy for us, your lordship.
on pre-made by the parties. List is matter up to 4 weeks.
item 9, 10, and 11 are.
Similar ones.
Supplementary cost list, item number 1.
Yes, Mr. Yes, I think.
Your Lordship, he is engaged in another court, Your Lordship.
Matter will be taken after
End of the board.
Yes.
On daily cost list, item number 1.
My lord, here we have to file the affidavit, my lord. Affidavit is ready, my lord. We'll file it within a week's time, my lord.
Your first state.
No, my lord, this is regarding Assam Rifle.
Awesome.
Yes.
Okay, oh,
School.
that's ARPS.
Yes, my lord. This is regarding 7th pay.
You have not got any stay order in your appeal. Have you filed your appeal?
No, not yet, my lord.
I'm still thinking.
On preempted by the Learned Counsel for the ERPS, seeking some more time to file the counter affidavit. The same is allowed. How long?
After 2 weeks, my lord, the matter will be listed.
This is matter up to 2 weeks.
Oblige.
Item number 2.
My lord, here I appear for respondent number 1, the collector, my lord. Yes, another case pending.
So all the respondents have not yet filed their counter. The respective counsels for the counsels for the respective respondents has sought for some more time to file the counter affidavit, as the same could not be done so. Sure. So I thought to sought for some more time to file. The prayer is allowed. However, the said counter affidavit may be said counter affidavit is directed to be filed within the next day. How long? As prayed for, this is matter for 3 weeks.
Item number 3.
So what happens here?
Your Lordship, in the 3 matters of PS Thankyo, order has been passed, but it seems the CMD is on leave of MECL, so the money cannot be paid till now also. So we require some more time with regard to the compounding of those cost audit years of 14, 15, 15.
This involved the MECL?
Yes. And the other items, that is Amrit Cement and Manipur State Power and Manipur State Power Company Limited. My learned friend had made a submission on the last occasion that the cost audit report was filed, but there was a delay. So even for the aspects of delay also, it has to be compounded. So I've taken instruction in Amrit Cements, so they have admitted that there's a delay. So now they're in the process of compounding the delay. Whereas in the other 2 items, that is Manipur, that I have also taken instructions, but due to the law and order situation and internet not working, and Your Lordship understand what is going on out there. They said as of now it's very difficult for them to come to Guwahati and meet the ROC to clarify whether there is a delay or not, because it seems to them they said their file on time. So on that, I still have to await instructions.
Well, as per the record from the ROC's office, one matter, that is Manipur State Power Distribution Company is 638 days delay, and Manipur State Power Company Limited is 398 days of
That's
delay.
what I'll take instruction on this.
Yes, yes. If they are to,
I've supplied the copies.
I'll take instruction.
If
They
they are
delayed.
to, concur with your findings as to the delay, then they may take necessary steps.
They'll take steps to compound the delay.
But the idea is to, I believe the petitioners are, willing to go before the ROC, get the matter compounded.
Yes.
And then start a fresh chapter.
Yes.
Once those are compounded, then nothing is left,
Nothing is
Lordship.
left.
Everything is closed.
Yes.
So the ROC has got the discretionary powers to do so.
Compound.
Yes. Under section 441, RD has the power, but the application has to be addressed to the ROC.
ROC, it
that
will
will
go
be
to the regional
forwarded
director.
to the regional director.
So as far as these, cases involving the CMD, MECL, so that process has already,
That order has been
done.
passed. It's only left now to pay the money for compounding. That is all. But now money has to come from MECL to pay the ROC, the regional director. So that I'll try to take steps from the company secretary of the MECL to expedite the matter.
Mr. Pinong counsel for the petitioner has submitted that as far as the formalities or compounding of the offences raised before the ROC, ROC, Register of Companies, the same has been duly completed and necessary orders have been passed in the affirmative. However, what is left is for the
payment
of, you call it penalty or what?
It's a penalty.
Payment of the penalty to be deposited before the said ROC,
Gotcha.
to which the petitioner could not do so, and for which some time is paid for a final order of the ROC to be produced for this court. On payment, let this matter be heard after how many?
4 weeks after vacations.
4 weeks. To go pada ka Amrit Cement.
2, 3, 4. Amrit Cement, they've already taken steps to compound.
Mr.
5, 3, 4, 6,
Nobel
7,
Council
8.
has submitted that the petitioner has already taken steps for filing necessary applications before the ROC for compounding
of the delay.
of the delay and related offences, for which some time is paid for the process to be completed and a status report will be filed for this court. On payment, let the matter appear after 4 weeks. Tiki Manipur pada orang hadir ni. Terkejut, Mr. Pinobri, letter counsel for the petitioner, has submitted that necessary instructions could not be received from the petitioner, whose they are companies.
That is item number 7 and 8. No?
7 and 8, my lord.
So Manipur,
They are companies.
they are companies.
Manipur State Power Company
Corporation.
Limited.
A company whose company is located at in the state of Manipur, and considering the prevailing situation in the said state, the necessary instructions could not be conveyed, for which the legal counsel has sought for some more time to apprise this court of the steps to be taken by the petitioner. On payment, this is matter up to 4 weeks. Mr. Dev, we'll see how they react.
Obliged.
Item number 12.
Lordship, may I please? This is, I think this is connected with item number 9, 10, and 11. Yes, Your Honor.
12 to same order betul ka Nehu.
Item number 13.
Have you filed?
No,
Who is to file there?
My lord, going to the record, my lord, I got one communication letter, my lord, this communication letter is given actually to the writ petitioner subsequently after the filing of the writ petition, saying that the approval order is not being granted by the authorities, madam. So I think if he is already having it, there is no requirement for me to file it through an affidavit, my lord, because our counter affidavit is already filed.
No, but have you referred to the said letter in your pleadings?
No, it's not.
No, it is not given in the pleadings of our counter affidavit.
Exactly. So how do you introduce it?
But we have already communicated to the writ petitioner.
Could be. If you are referring to it, you see, and producing it in court, that's a different thing. Communication to the petitioner is one thing. He may say yes, he may say no. But, you know, in black and white, it has to be produced before the court.
I'll request some more time, my lord, because this
2018 letter, Mr.
Because this letter was has been it's a subsequent development, my lord, and at the time of filing of this affidavit, it did not occur to us that we should include this also.
Yes, because subsequently you should have filed it. If it has relevance to the case, then you should have done it.
But then
do it within 1 week.
But then, my lord, the fact of the matter remains is that whether this permission is granted or not granted, we do not know which came in first, the high tension wire or the building. So for that,
so in that sense, that permission that you have declined would be relevant.
our is only to the extent of construction of the building, but then whether the high tension line was still in existence or it came subsequently, that will not be established by this document.
Then why should we look into that?
No, because he is stating that his building premises is being affected because of the existence of the high tension power line, and they are saying that if you are to shift it, the writ petitioner has to shift it with his own cost, and the MEPTCL is saying that no, you are to shift with the cost to be paid to us. So that is the main crux of the case.
And your lordship, in this case, I filed an additional affidavit recently, okay, stating, because there's a last order was that to bring the inception of the unit. Detailed report I've already filed in my affidavit, okay, whereas from the respondent number 4 and 5 and for the state, nothing has been.
So the question to be answered here is whether the building came up first
or the high tension,
or the high tension.
High tension building and that entire unit has come first. We already filed a detailed affidavit bringing all the communications and the permission given to us.
Affidavit dated? I think if my learned friend makes a compilation and makes it ready, so that at the time of hearing we can get it all.
What compilation is required?
Affidavit.
Yeah, it's affidavit dated, lordship. Yes, 23rd August 2022.
Just give me one copy.
No, already supplied.
No, you give it, but maybe I misplaced. Xerox or more. You give it to me. Xerox. I'll get it Xerox, man. I must have misplaced it. It আমার কাছে নাই। আমার কাছে না। Another 2 weeks time, my lord, I'll make attempt to communicate with my officers, my lord, because the officer, the affidavit needs to be filed, my lord, and in between. But that will not establish who came in first, whether the building came in first or the high tension line. Our statement will be saying that his building construction has not been made with the approval of ours, my lord, only to that extent. But it doesn't say.
In that respect also we have already filed and things, affidavit, okay, and one there's a blueprint which has been countersigned by the department who gave the permissions.
So this is wrong statement. We already filed there on record, Your Lordship. And this is the affidavit where the court has asked that to bring on the details of the things, documents, who came into inception first. So
Exactly.
this is
I think that is the moot question to be answered.
questions.
And in our counter affidavit, we have very clearly stated that the department, not the MEPDCL, the industrial department has also been providing all the cooperation for setting up of the high tension line. Because before setting up of the high tension line, they had demanded assistance from all the concerned. So in that respect, we had given also. That one is part of our counter affidavit.
And as far as the in my writ petitions, three documents are there, which have already said that the respondent 4 and 5, that is MECL, has taken no objection department, and they have just constructed this. It is their state, it is their document. And later on, this show cause has come to us.
What I believe is that, my
There
lord,
afterthought.
several disputed questions of facts are there, my lord. I think the civil court will be the best court for getting the appropriate relief, my lord.
No, this is not about the titleship, Your Lordship.
No, because the disputed questions cannot be ascertained by way of...
That is a different thing.
That's different. It is not about the titleship.
Why, my lord, I am saying is that there are several questions. When did the industry started? When did the power line started? Who started? What is the date of approval? Everything. All this will have to be examined, cross-examined, and everything. By way of pleadings in a writ proceeding, my lord, it will be difficult, my lord. That is why I am saying that the appropriate relief is, if to be obtained, my lord, it will be by way of...
But as far as you see, as far as the
enforcement is concerned,
as far as writ court is concerned, certain matters are only to be looked at prima facie.
Prima facie.
See, details.
But prima facie, my lord, we are unable to ascertain for the last so many years who has come into existence first, and the petitioner is saying something else. The state authorities are saying something else. So, my lord, prima facie also is is creating dispute and doubts, my lord. That is why I am saying that this will be one of our contentions, my lord.
Prima facie, in my writ petition, page number 23, annexure 8, it's clearly stated that the department itself, how they violated. Now they are saying that the prima facie there's no case, the civil court. We are not here discussing about the titleship. Nobody disputing my title. I have the permission, I am doing my business. I am paying all the taxes to the charges to the government. If somebody come and enter thing and we inform the department, and department instead of taking the action, now they are saying that no, this is a disputed matter, this should go to civil court. The civil court has the jurisdiction only for the title, if the title dispute on the titleship.
No, my lord,
dispute on the title.
Even other disputes also, my lord, which disputes needs to be ascertained by way of evidence, that cannot be decided.
Let them file the affidavit. Let them file the affidavit. I'll file the rejoinder to it. Then let's hear it. If the matter is pertaining to the civil court, then we'll go to civil court.
I think we should, yeah.
I'll need time to file my affidavit.
Put an end to this. Otherwise, it goes on like this. Makes no sense.
It makes no sense after all.
And moreover, Your Lordship, whenever the court has directed the petitioner to file the certain things and everything, we have filed in on time. There's no delay. The delay is going to part of the respondents.
You are paying for MECL?
No, MECL is Rosie.
The affidavit is sought to be filed by the state?
By the state, the industries department and the state department. We'll make all attempts to file the affidavit. Because it was
maybe the last chance given.
Yes. Not last chance. It's
a 2018 matter.
No, that is what I am saying. We have given the copy to him. It should be in his hand.
Whatever the case may be, you bring it on record. If he chooses not to do, you do it.
Yes, we'll do it.
Mr. S. N. Gupta, Leonard, additional senior G, appearing for the state respondent, has sought for some more time to file the said additional affidavit on the ground that necessary instructions have not yet been received. The court generally would allow such prayer in normal course. However, it is noticed that this is a long pending matter, and it is incumbent upon the parties to ensure that the matter is disposed of at the earliest. Be that as it may, the said affidavit is allowed to be filed within the next date fixed. Failing which the matter will be heard and disposed of.
Obligation.
This is matter for 3 weeks. So 3 weeks time, Mr. Senguta?
3 weeks.
So whether you do it or not, will.
Yes, we will proceed.
Lordship, I just have a simple prayer, not to be fixed on 30th of October. Anything on because I'll be out of station.
Okay, so tentatively we may go to the first week of November then.
Okay, Your Lordship.
Which tarikh?
First week now.
First then.
First.
Item number 16.
Yes.
Lordship, some excuse, Lordship. What happened is that I was leaving time and I instructed my colleagues to keep the file back. But inadvertently, they also forgot the file, Lordship. In fact, we are ready with the matter.
What is this matter about?
Lokma matter. Lokma matter.
So, Mr. Hajarka?
It may come after a week, my lord.
After a week, I will have some difficulty, my lord. Let it be after Puja, my lord, the first week of November. It's a very short matter.
But it may be confirmed by my friend that after Puja they will do.
Yes, yes.
On prayer made by the respondent. Your respondent? Number?
Number 4.
Not objected to by petitioner. Matters adjourned. Just the same after Puja vacation.
Hello.
All right.
Second call from supplementary cost list. Item number 1.
So, Mr. Chaudhary, you will respond? Or
Yes,
who will
I will
respond?
start. Because Lordship was pleased yesterday to.
Yes, you are for respondent number?
I am for the responding school respondent 9 to 11.
Please.
Lordship, I will just take Lordship's little time because my friend has taken yesterday this other time mood of appraisal was something new, making a compilation statement. And when I went through my copy, I found pages are not similar. What is submitted, and I may take the help of my friend's copy, which is more or less right. Now, Lordship, I beg to submit here the entire matter in this case, what we heard yesterday, is that on the third batch of writ petition, this is the third. First was in 2002, and then it was in 2010 and 9 also, and then now it is in 2015. Now, what is sounding in his submission is that his service was terminated from 15/3/1995, and he is claiming the salary from 15/3/1995 to 1/3/2009. 1/3/2009 means the order by which the first batch of writ directed that post may be created, sanctioned or transferred to the school so that both the teacher, science teacher may be accommodated and they may get their salary. Lordship, I beg to submit here before I proceed further. So this post of science teacher, it is a sanction scheme post. It is not a post like other teachers of born on this deficit scale, etc. This is a fixed one. So there is no such other benefits which the other teachers get. Now, after the first batch, let me apprise to your Lordship, the first batch was, before the first batch concluded, the conclusion before that, what happened, the problem started when the school committee appointed respondent number 12 as the regular science teacher in sometime in November 2017. So it has started from that point of view, 1999, yes. So for that, what happened? The present petitioner became aggrieved. He aggrieved. When his service was terminated from 15/3/1995, and he was offered that if he is willing or interested, he may work as an additional science teacher. He agreed, Lordship. And for that matter, Lordship, I will have to refer to my affidavit in opposition, which was filed on 14/9/2015. That is most important, Lordship, because this will give Lordship the entire picture. Thereafter, he has filed rejoinder, we have given affidavit of facts. I will go one by one, Lordship, as per the procedure. Lorships, if Lordship get my affidavit in opposition dated 14/9/2015 filed, if it is available, Lordship.
You are respondent number?
Respondent number?
910.
Yes, 10. As the Secretary of the Managing Committee is given, Lordship. It is on his behalf and also on behalf of the school and the chairman of the, president of the school. Means covering 9, 10 and 11. So your Lordship will find in page number 2 of that, the fact behind the case the Secretary has stated in his in this affidavit that the writ petition was filed is a preconceived one.
Yes,
para number 3, page 2.
Yes.
The writ petition is filed by the petitioner is a misconceived one. In this regard, it is most humbly and respectfully submitted here to say that the writ petitioner conveniently suppressed the material facts. It is a fact that the petitioner was appointed as a science teacher purely on temporary basis and subject to termination without assigning any reason thereof with effect from 21/9/1994 and continued to work as science teacher till 28/2/1995 against the ad hoc grant for the science teacher, and subsequently his service was terminated as per the then managing committee's resolution dated 15/3/1995. Lordship, I am coming to that point, that is 15/3/1995 resolution, which was approved by the Inspector of Schools, West Garo Hills, by his memo number such and such dated 26/6/1995. However, it is proposed from the school authority that if the writ petitioner was at all interested to work as additional science teacher with lump sum of ₹1,000 only per month as remuneration with effect from 1/3/1995. Kindly see your Lordship, 1/3/1995. He may work with, and the writ petitioner accepted the proposal and worked as additional science teacher till 29/2/1996 on the same salary and from 1/3/1996 to 28/2/1997 at the rate of 1,500 only per month. It will be appropriate to mention here that the writ petitioner's service was again terminated as science teacher with effect from 31/3/1998, while during that period of 1/3/1997 to 31/3/1998, the writ petitioner refused to accept salary at the same rate on different pretext. But what happened? And that period he is working 13 months. At the end, he has become reluctant to accept the salary. In this regard, Lordship, I shall humbly draw the Lordship's attention to Annexure C at page 39, Lordship. Annexure C, 1, 2, 3, these are serial, as running page 39.
Mr. Chaudhary,
yes,
just one. You have mentioned here,
yes, Lordship,
at para 3 that he was offered to work as additional science teacher.
Yes, Lordship.
On payment of 1,000.
1,000 initially, and thereafter,
for which he has accepted.
Accepted.
Where is the document?
Yes, that is the I am just referring Annexure C at page 39.
No, this is the.
These are the salary.
Yes.
These are the salary. I mean C1 to C13. Means 13 months. So my humble submission is that once the petitioner has accepted the matter, he has a fate accomplished and acted, is he not stopped under the principle of estoppel to come forward? This is my first principle I am just submitting.
But the fact remains, if he has disputed the fact that you have offered him to work as additional science teacher.
He has not disputed.
He has
not disputed. He has acted up to 13 months.
That document has to be here.
No, that is not disputed. There is no.
Where is, you said that you have made a proposal. He has accepted that proposal.
No, that is our resolution dated 15/3.
Where is it?
That is there at page 34. Resolution is 15/3/1995.
Where is the type copy?
That is resolution number 1.
Where is the type copy of this?
Pardon, Lordship, at 34.
Type copy of this?
Oh, type copy. Type copy is there. Type copy is in 37.
37?
Yes, Lordship. I think Lordship got it.
Yes, please.
It is Annexure B, it is coming in that way. Page 37, resolution number 1. The Secretary informed the meeting that due to students' pressure and considering the necessities for ensuring proper taking of science and mathematics classes, he had to appoint Sri Sameer Reza, a local science teacher, science graduate, as science teacher subject to approval of the managing committee with effect from the date of his joining in his duty. And this was done as an emergent measure to meet the likely situation of shortage of science teacher as might arise due to the fact that the existing science teacher, C. Imam Abu Abdullah, is an outsider and might be disallowed to continue in the post as contemplated under resolution number 1 dated 7/8/1994, together with that of referred to above. Accordingly, the Secretary moved the meeting to approve the appointment of Sri Sameer Reza. Considering all these aspects, the meeting resolved the approval the appointment of Sameer Reza as science teacher with mathematics, with the direction that the Secretary either to allow Sri Imam Muhammad Abu Abdullah to continue as science teacher or to serve him with the notice that his service is no longer required in the school and to take necessary action accordingly. So this is the resolution, and that has been communicated to him, and he has acted, Lordship, as I have just...
Where's the communication?
Communication is no other communication is made.
Then?
Let me proceed, Lordship. I think I will get it. It is there, Lordship. We'll get it. Let us proceed.
No, Mr. Chaudhary.
Yes, Lordship.
Be clear, you see. Go to the facts in order, so they will not be confused. See, you have to first ascertain that he has received your, the copy of your resolution, whether he has accepted or not. That
Lordship, we are trying to impress upon the Honorable Court that he has accepted this proposal and he has acted and worked as an additional science teacher for 13 months. That is my submission here up till now.
Fine.
He has accepted it. Now I am just going to that paragraph 3, page 3. It is appropriate to mention here that the petitioner's service again terminated such and such. I have read about that. The writ petitioner refused to accept salary at the same rate on different pretext. The amount of rupees 19,500 only for 13 months has been paid to the writ petitioner along with dues for the period 1/3/2009 to 31st/5/2009 being 18,000 rupees. And at the rate of 6,000. His basic contention that he has not received his salary. But we are showing that his salary is how it is paid. This is the way in the affidavit we are trying to impress upon the court that money of 18,000 for this period has been at the rate of 6,000 only per month, being the entitlement dues by State Bank of India, Rajawala branch bank draft to the registry of this Honorable Court as per the order dated 10/4/2015 as passed in the contempt case number such and such out of the common judgment and order dated 14/2/2014 as passed by Lordship. What happened?
You are reading what part, Mr. Chaudhary?
I am reading the second para of my affidavit in opposition at page number 3.
Just a moment.
Page number 3, running page. Lordship, because this is the third round of fighting, therefore we are to say previous two points. Before that, if I am allowed to make my appointment, effort, let me give a brief reference. I think it will be very much clear, Lordship. Lordship says that referring to affidavit in opposition dated 14/9/2015 to the writ petition by the school, in paragraph number 2 I have said, the writ petitioner's service was terminated as science teacher against the ad hoc grant of the School Managing Committee Resolution 15/3/1995 and was duly approved by the then Inspector of the School, now called District School Education Officer, Annexure B at page number 34 of our affidavit in opposition. Now, however, the service had again an opportunity, the School Managing Committee has given opportunity to the writ petitioner to work as additional science teacher at a fixed salary of what he worked of being, and he worked being agreed in 3 intervals: 1/3/1995 to 29/2/1996, then 1/3/1996 to 28/2/1997, and 1/3/1997 to 31st/3/1998 at the rate of 1,000 and then at rupees 1,500 per month for 13 months. The writ petitioner, having agreed and acted upon, worked as additional science teacher. The school respondent had appointed formally Srimati Ismatara Rahman respondent number 12 as regular science teacher with effect from 17/11/1999 against the science grant. I think I'm getting now slowly, Lordship. The first round of starts now, first round. The writ petitioner being aggrieved filed the first round of legal fight by writ petition C on 168 SH of 2002. And Simoti Ismatara Rahman, respondent number 12 here, filed another writ petition by writ petition number 185 of 2002. This is the first fight. Claiming that she is the regular science teacher, and this will be available in paragraph number 3 of the affidavit in opposition, what your Lordship is now perusing.
Yes.
As per appointment letter, as her appointment letter was regular and approved by the Inspector of Schools, West Garo Hills, Tura. Lordship, I beg to submit, because of my opportunity to working with the high schools as a managing committee member and as the president of the committee, 2 schools, high schools, I have directly handled the school matter with government. So that is from my practical experience. I'm just submitting, Lordship, that she's saying that respondent number 12 by the writ petition 185 of 2002 that I'm the science teacher. By that order dated, what happened? In between, there was a development. Development was that in the 168, what happened? The present writ petitioner has taken an interim stay. Interim stay was that he should not be removed. He should be taken back as the science teacher. But thereafter, what happened? Thereafter, Ismatara Rahman, thereafter the school managing committee made an intervenor petition by one miscellaneous case, 134 of 2000. Yes. Worship, because worship, it's very difficult, Lordship, to such a complex matter, because I had to prepare myself in a combined way because of his combination matter. What happened? Then, when the school made an application, interim application in 168, that this, how can we take it back, because Ismatara Rahman is already appointed and her appointment is already approved by the school. Then there was a modification of the order. The order was that on 24/5/2002 in 168, the learned single judge said that he should be taken back as regular science teacher, present writ petitioner. Therefore, the school managing committee had to intervene in the order, saying that we are in a dilemma, Lordship, because this already Ismatara Rahman, the present respondent number 12, has been appointed. Now, please render a modification of that order. So a modification was made about that miscellaneous petition on 26/6/2002. And that, I'm just reading, Lordship. The headmaster cum secretary of the respondent school terminated the service of this PW 12 because writ court has directed that present writ petitioner to be taken as a regular science teacher. So what to do? Because we have got only one sanction post. So what to do? School committee said that to Mrs. Rahman that if you want to serve, you may serve as an additional now, because on court's order we must carry it out. And if you think you may do, or you may your service will be terminated. Then she filed this 185. And in that 185, what happened, Lordship, another set of judge has given that her service should not be, she should be taken back. Now kindly see, here is this clash. Here is clash. And that clash was more made effective when over this modification of 26/6/2002, by which the Honorable Single Judge modified his earlier order of 24/5/2002 of taking the present writ petitioner as regular, it was modified in a reverse manner. That, no, I am modifying that the present writ petitioner should work as additional science teacher and Mrs. Rahman as regular science teacher. Now kindly see what is the position for the school. So when this modification order of 26/6/2002 was made, this present writ petitioner became aggrieved. He went to division bench. So division bench, he filed a writ appeal on file number 17 SH of 2002. There on that day, Your Honor, the Honorable Division Bench has stayed the modification order of 26/6/2002, and as a result, what happened? The position of 24/5/2002 restored. Can you see what the position has become now? Now, after the Honorable Division Bench has given a specific direction to the single judge, within such and such period, expeditiously dispose of the matter. Now what happened? There comes the order dated 28. What is that order? 28/3/2006. 28/6/2006. It is available in page number 97 to 2002. 192. This common judgment rendered on 28/3/2006 is available in the compilation filed by my learned friend at page number 97 to 2002. 102, sorry, Lordship. 97 to 102. This order will give Lordship the exact position.
Page 110.
102. It will be better, Lordship, if I refer my affidavit in opposition.
You have annexed this order?
Yes, that I have. I have annexed all the orders, modification, everything.
Even my compilation also page number 90 to 95.
Yes. All right. That may kindly be referred also, because mine one is giving in a different way, and his one is going in a different way. Because this compilation has become the guiding line now nowadays.
See, compilation does not necessarily mean only for the petitioner. It is for reference for all parties.
Yes. I'm coming, Lordship. Given. Lordship, if I go serially to my, then I can find it out very easily. Compilation means 97. 95
Lordship, it is at page 97 of the compilation.
Yes.
Common judgment and order. 28/3/2006.
Yes, it is here.
Yes.
Which part you want?
I will read it. Paragraph number 7, Lordship, if your Lordship goes to paragraph number 7, because what was the fate of this case? On that day, the managing committee was not represented. Nobody is there from the managing committee, only respondent number 12 here and the writ petitioner here. They were contesting.
Yes.
Now, if you go, Your Lordship goes 102 page number.
Yes.
It directly says, in such a situation, what I have just described, Lordship, the situation I have explained to Your Lordship, in such a situation, I am of the view that only possible remedy to the solution would be a direction to the concerned authority in the state government to sanction a second post of science teacher for the school in question, so that the writ petitioners in both the cases can suitably be accommodated and the salary, etc., as may be due to them can be without any difficulty, can be paid without any difficulty. Though creation of post is primarily an executive function and such direction are rarely issued by the court, in the present case, resort to such an extraordinary step has been made as the present impasse, which has necessitated such a direction, has been occasioned by the action of the jurisdictional inspector of schools, as has been noticed. And you see, this is the comments the Honorable Court made.
Yes.
With the above direction, this court will now be compelled by the concerned authority of the state government as expeditiously as possible. Both the writ petitions shall stand closed and answered in terms as above direction. The copy of this order be furnished to Mr. S. Shen, learned government advocate, as prayed for. So that is the position. Now my humble submission is that once this position has been settled finally, so the present writ petition and also the second round of writ petition are barred by res judicata.
On the basis of this order,
yes.
So additional post was created.
Yes, Lordship. The state has preferred an appeal. Appeal was also dismissed.
Yes, yes.
And thereafter the
Yes,
additional
yes. I'm coming, Lordship. I'm coming.
Where is that sanction?
I'm coming, Lordship. Because this is in a batch and by batch way it has gone. It is difficult finding to place it. Your Honor will get when it is here, when what is called an appeal was filed by the state government and it was rejected, and then a contempt petition was filed, and against that contempt petition, what happened? The government made a bit delay and the contempt petition was filed, and during this course of hearing, meanwhile, the government complied with. Now kindly go through my page number 69 of my affidavit in opposition. Not that,
69.
Not that, Lordship. So many documents, Lordship. It is here, Lordship. We have given it. If I go serially, Lordship, then it will come automatically. That is a letter granting aid. You should come afterwards, Lordship. It's not here.
bench order, Your Lordship, in my compilation 119.
119, na? Find out 119. Wasn't given in a rejoinder affidavit.
Contempt is 128.
I want actually contempt, first contempt petition.
Contempt is, Your Lordship,
No,
page
no,
118.
I'm not.
128.
128, Lordship.
What I want to look
120 of the compilation.
What I want to look at is on the basis of this order, it has gone through contempt process, whatever. But finally, the government
has complied with and transferred a post and attached to the school.
Okay, so they have just transferred.
Yes.
So where is that? Where is that communication?
It is communication is here. Communication to Communication is there, Lordship. I have given it along to my rejoinder affidavit. My rejoinder affidavit I have given. This is a problem, Lordship. So many correspondences. Lordship, please give me little time. A bit of making facts.
See, release of grant of money is one thing. Sanction of the post is another thing.
Post has been transferred, Lordship.
Whatever, sanction or transferred.
This communication, Your Lordship, is never produced, Your Lordship. This communication never produced.
No, yes, produced. Don't make misleading statement here, please.
So let them show Your Lordship this.
I can show you because we have, Lordship, if your Lordship goes through my written argument I have given already, there I have referred clearly. Written argument.
No, written argument is separate.
It is there.
Written argument is separate. If you have pointed out in your written argument, it must be in your pleadings.
Must be, it is given, Lordship, given.
Well, anyway, see, pleadings of either respondent,
giving, Lordship,
state respondent or the private respondent. Yes, Mr. Sengupta, are you aware of that? Where is it?
The post was created, my lord.
Created? First they said transferred, now you say created?
Transferred, my lord. I mean to say transferred, my lord, on the order of this court, my lord.
But where's that communication?
We have not brought on that.
No, we have brought it. I have brought it. Lordship, kindly give me little time. So many papers, Lordship. I do remember I have given it. I go by that. It is in the affidavit in opposition, it is there.
Should be.
पर तो निकालना नहीं सीख रहे हैं ना. Because we have given it. Which one I have given? I have forgotten. इसमें आएगी नहीं देखो तो. इसमें नहीं मिल रहा. तो इसमें नहीं मिल रहा. We have given, I remember.
Page 122 of the writ petition. Mr. Devnath?
Yes, sir.
Is this not the one?
this is the amount of salary has been.
Page 122 of your petition. That order dated 1st June 2009.
Yes,
It is reflected only the one post has been transferred.
Yes. So one post has been
transferred, Lordship.
Approved to transfer one sanctioned post from so and so Derry Linda Persera.
Yes, Lordship.
Secondary school to so and so in compliance with the court's order.
Yes, that is that is.
So this transfer or sanction is personal to the petitioner.
So, Your Lordship, after that, due to this, Your Lordship, after that I referred that when salary was been paid and released, it is star mark is given and name of the respondent number 12 has been reflected. So, no separate order is available other than this. So, this is just I meant for you.
Yes.
And when
Yeah,
the salary,
I think Lordship got it now satisfied.
Yes, please.
That post had been transferred. Now, for this purpose, Lordship, what happened? The contempt filed by the present petitioner was dropped. Now, here is the peculiarity of the case again. If your Lordship goes through the contents of the order, it is in 54. This is you are giving. Big petition. I think compilation will be better, Lordship, 128. So many rejoinders, so many where it has gone. So compilation is now helping us in that way.
$128 is the order.
Yes, Lordship. Now, I'm just trying to draw Lordship's attention. It goes like, heard Mr. Siddiqui, learned counsel for the petitioner, and Mr. N.D. Shulai, learned counsel for the respondent. The order to be complied with in this content petition is the direction given in para number 7 of order dated 28/3/1996, passed by this court in WPC number 185 of 2002. Here is the mistake, Lordship, because this contempt petition is filed by the petitioner of 168 of 2002, not by 185 of 2002.
See, that makes no difference now.
See, this is the wrong submission given by the learned lawyer who moved the matter.
Sorry, that whatever the case may be, the fact remains that on the basis of the contempt, could be in 168 or 165, the government has complied with the order and created or transferred one sanction post. So that this court is satisfied on that aspect.
Now, this court has, contempt court is given on the, kindly see, in the second paragraph. Mr. Sulai, learned counsel for the respondent, submits that the proposal to create one sanction post has been given approval by the government, which is reflected in the communication dated 27/5/2009, issued by the Deputy Secretary of the Government of Meghalaya Education Department. It is further submitted by Mr. Sulai that pursuant to the approval given by the government, as discussed above, the Director of Higher Education Meghalaya, by communication dated 3rd June 2009, informed the learned government advocate to apprise the court that by way of complying the order of this court, one post from Derry Lindra Secondary School has been transferred to Holiday Grange School with effect from 1/3/2009. In view of the above, the order of this court has been complied. Accordingly, this contempt petition is closed. Copy of this, such and such, such and such. Now, what happened?
Yes.
Now, the writ petitioner here now giving a picture that since this contempt petition is filed by the writ petition of 185, as such the transport post is she is to be attached against the transport post, and I am the regular science teacher, and giving an impression that the first batch of roundup, which was on 28/3/2006, has decided he is the regular science teacher.
Yes, that
where it is decided.
That is what the order says.
No, it does not say like that.
You read the order dated 1st June. Read the order dated 1st June, issued by the government.
Yes.
Again, you read that order. Where is it? Page?
In which page, Lordship?
122 of the writ petition.
122.
But I don't know, in your compilation, where is it?
Yes, Lordship. Is it that?
Have you got it?
Yes, Your Lordship. Now, kindly see, Lordship, if we...
122. Yes. You read
the 122 page.
Yes.
Now, this is a letter from the Directorate to the Inspector of Schools.
Yes.
With reference to the subject above, I am enclosed here with the government letter dated such and such, has approved the transfer of one sanctioned post from Dairy Lindra Parsara Secondary School, Holidaganj, in compliance of the Honorable Court's order, and this order will be till the retirement or resignation of the petitioner.
Yes. So
now kindly see.
So who is the petitioner here?
Petitioner here, the present petitioner.
Yes.
So this transport post is for him.
For him.
Not for respondent number 12.
Yes, not for respondent.
So this is clear now, Lordship. So this wrong submission and the contention made in the writ petition is misleading the court, and it is difficult to resolve. Now, when the question is now ended that the transport post is meant for the present writ petitioner, Imam Mahmood Abdullah, now how can he demand that he should be given salary from 15/3/1995 to 1/3/1999? Their salary is taken and given by the school managing committee as per the second round of writ petition, when the Honorable Court directed the state respondents and the school respondents are directed to pay the entitlement of the school teachers. So, as your Lordship understands, that in the matter of appointment and day-to-day administration of the school, it is the managing committee knows who is discharging what duties. Government simply gives grant.
Yes, that is.
Simply gives. Government doesn't interfere in the management of the school. So, what happened here, after this transfer of the post and sanction is given for that transport post, and the content petitioner is to be added or to be attached against that post transfer, the question of making claim that he wants a salary between 15/3/1995 to 1/3/1999. 1/3/1999, it is the date of transfer of the new post. So between this period, 9 years and 13 years salary, he claims that 13 years salary, whatever is given, it is my salary. That is the claim, Lordship. Now kindly see, I am now trying to proceed further in this regard. Just submitting. Finding delay in the compliance of the order dated 28/3/2006, the writ petitioner filed a contempt petition by Contempt 9 of just referred 2009, Meanwhile, the state government respondents created a post of science teacher I have already submitted, attached with the respondent school, subject to the condition that the said post will be retained by the school till the retirement and resignation of the petitioner, means the contempt petition. That is Abu Alam Abdullah, the present writ petitioner. Therefore, Lordship, the present writ petitioner has got accommodation in the respondent school with effect from 1/3/2009. His regular accommodation is from 139. And from that, he is getting, I will come, Lordship, how the writ petitioner or his counsel on record has misled the court, giving rejoinder, this and taking allegation, applying for right to information, these. I will come to Lordship and satisfy that how the school was harassed by this teacher. Therefore, Lordship, the present writ petitioner has gone. Said part of the long fighting by the writ petitioner is that he is claiming without any basis the order passed by the state respondent dated 27/5/2009, Annexure 24, enclosure A, B, and C, page 122 and 123 of the writ petition, Lordship. Because we are finding difficulties because we are not going as per the usual process. We have started from the compilation, but I have prepared my submission according to our usual process. So this is available at page number 122 and 123 of the writ petition. Shows that the post so created in the school by way of transfer is meant for the contempt petitioner in the COP number 9SH of 2009, Abu Abdullah from 1/3/2009. I think up to this I could satisfy Your Honor. The second round now coming. The second round, now my one question is this: if he was not satisfied, he should have gone on appeal. Until he goes on appeal, the orders passed by the learned courts remains. But he was not satisfied. He filed a second round. The present writ petitioner filed a second writ petition by WPC number 137SH of 2010, claiming on his self-assessment that by the common judgment and order dated 28/3/2006, the Honorable Court adjudged him as the regular science teacher without impleading the present respondent number 12, who was holding the post since 17/11/1999, and so she filed the second round of writ petition by writ petition 247 of SH of 2009. Kindly see, once he filed 132 of 2010, already at that
137 or 132?
137 SH of 2010. It is the second round of writ filed by the present writ petitioner, claiming again nursing his claim from my 15/3 of 295. I have not been paid my salary. Because High Court has stated that I am the regular science teacher. Where it is stated, I have not seen, Lordship. I will satisfy, Lordship. Then what happened? Mrs. Rahman, the present respondent number 12, filed a fresh writ petition because her right is involved here. So in the said second round of writ petition, 137 SH of 2010, the writ petitioner claimed for a direction to be made to the respondent school for releasing the entire salary with 12% interest to him, as he is the regular science teacher. Second round. Regular science teacher. After hearing both the counsels of the writ petitioners in the second round, the Honorable Single Judge directed both the state respondents to pay the salary to both the teachers as per their entitlement by its order date, common order. Again it is common order. Common order dated 14/2/2012, Annexure 16 at page number 77 to 81 of the present writ petition. It is available in the present writ petition at page number 77 to 81. It will be busy, Your Lordship, instead of going this compilation, if we go by the writ petitions and the show cause affidavit, additional affidavits, this will help us, Lordship. Now, when this was the order passed by in the second round, the present writ petitioner again became aggrieved. Because I have understood that in the second round, the Honorable Court has not given him specifically the benefit for that he is entitled. So he went for a review petition. So that review petition, the review petition out of the order dated 14/2/2014 was filed by review petition 3 of 2014, which was dismissed by your rejection. And if Your Honor goes through, Lordship goes through the body of the order, the Honorable Court has rather become astonished whether I am unable to understand whether it is an appeal or it is a review petition.
Where is that? Where is that order?
Order, I'm order I have attached, Lordship.
Yes, where is it?
My first affidavit of opposition was in detail, Lordship. I think my friend in the compilation has not given. Then another contempt was filed.
Just one minute. First, let's go step by step.
Yes, Lordship. It is page 87 of my affidavit in opposition. Page 87 of my affidavit in opposition, filed on 14/9/2015. Page order dated 6/3/2014. I think Lordship got it. Page 87, running page.
Yes.
Honorable Justice S.R. Sen, review petition number such and such. From the language of the petition, third paragraph, it is understood and clear that the learned counsel had drafted the petition in a poor manner, and this language may be used if the petitioner moves before an appellate court. Because the review court pattern and his review petition he filed is more akin to an appeal than the review petition. However, the review petition was rejected. That is the comments only made by the Honorable Court. Page 87. I think Lordship got it.
Yes, yes.
Now I come to the next step. The school respondent, after by that order of 14/2/2014, 14/2, the burden came on the school to pay the entitlement of the teachers. Now, as Your Honor, Lordship understands that this school cannot do anything and whimsically, so it has consulted the local DESO, means or Inspector of Schools. So it goes like that the school respondent in consultation with the state respondent.
You're reading what part?
I am reading from my own preparation, Lordship. I will satisfy it. So what happened? That Your Honor, Your Lordship will find when a contempt petition is filed, in that reply it will be there. I'm making it a joint. So in compliance of that order of 2014 to 2014, which was approved by the district school education officer, Tura, but the present writ petitioner did not come forward to accept the payment. So the respondent number 12 here, and the other science teacher received her payment. Now what happened? Now when the responsibility is given to the school managing committee and the state respondent, pay according to their entitlement. So the respective entitlement, as I have just submitted, Lordship, that who is the regular science teacher according to the Honorable High Court's order. So payment was made and information was sent, please come and collect. But the writ petitioner did not come and collect, but respondent number 12 came and corrected her matter. Now what happened? He has filed a contempt petition. Now let us come to the contempt petition, Lordship. Again, it will be in our affidavit in opposition. Lordship, page 70 of my affidavit in opposition. Means first affidavit, means affidavit in opposition. (73) is the appropriate page. 73.
Yes. This is the order dated?
Order dated 10/4/2015.
Yes.
Now it goes there, Mr. R. Devnath, learned counsel, appears for the petitioner. Learned N.D. Shulai, senior government advocate, assisted by Sri H. Kharim, learned such and such. Sri R. Chaudhary, learned counsel, is also respondent number 6, 7 and 8. Mr. R. Chaudhary, learned counsel for the contemnor, respondent number 6, 7 and 8, states that he will advise his client to keep the bank draft ready in the name of the petitioner to be handed over to him on the next date of hearing in the case. In case of any controversy over the exact amount of entitlement, it would be open for the writ petitioner to seek clarification from the court, which has passed the order sought to be enforced by filing a contempt of case, list this matter on 24/4/2015, Lordship. This is the first appearance orally I submitted given the show cause, and the Honorable Court said that between this period you pay the amount. Next date is 24/4/2015. Exact page is 81. 24/4/2015, Lordship. 81 page.
Yes.
This is a contempt case 3 of 2015 in WPC number 137 of 2010.
Yes.
Mr. R. Devnath, learned counsel, appears for the petitioner, learned such and such, such and such, such and such, learned counsel respondent, R. Chaudhary, learned for the counsel for the respondent number 678. On the last date of 10/4/2015, this court passed the following order. So that order I have already read, Lordship. Now, today the learned counsel for the writ petition, the counsel C.R. Chaudhary, states that In terms of the said order dated, a bank draft of 37,500 has been deposited with the Registrar General of this court. Thus, it would open for the petitioner to receive the bank draft in accordance with the procedure being followed. As this court has already given liberty to the petitioner to seek clarification from the court which has passed the order, so no further order or observation is required on that court. Thus, contempt petition is dismissed. Now, what was the direction of the contempt petition? Contempt court, that you want to seek clarification. Instead of seeking clarification from the or review to his review failed. Then instead of that, he has filed a fresh writ petition before this honorable court. This is the fresh writ petition 132 of 2015. Where is the direction by the court to seek clarification by way of review? A review was, as Your Honor, Lordship has found, was rejected. Now, where is the scope to file the present petition? It was given only for clarification. That I made a prayer for that. Lordship has given a summary order to kindly decide it, my fate, as per the prayer made in the writ petition. Instead of that, he filed a new, fresh writ petition.
Yes.
Now, so contempt is also, Lordship,
yes,
satisfied. I am unable to say now at this stage whether he has withdrawn the amount or not. The school has discharged his duties as per the Honorable Court's direction.
No, he has said that he has not yet withdrawn. He is still with the registry.
No, wait. I'm proceeding, Lordship. Fine. The third round. The present writ petition is the third round of litigation by way of writ petition on a disputed fact that the writ court cannot decide legally, being the subject matter of civil court, if any. Now, at this stage, as on this date, as the good sense prevailed, the writ petitioner has accepted and received all his salaries after asking him repeatedly by the school and the district school education officer to receive. Otherwise, the entire amount will be refunded to the state government account. Now, there is another funny thing here. After 1/3/2009, when the new post was transferred and he was attached with that under the government order, still he was not accepting the payment. He was thinking, probably, my wild guessing, or your Lordship may say conjecture or surmise, that if I accept this payment, then my payment, as I claimed from that 15/3/2009 to 1995 to 1/3/2009 will go. Therefore, he was not taking. So when there was a heavy accumulation of about 9,90,000 of rupees, and repeatedly he was asked, please collect your money and salary, he was not coming and taking. Instead, Lordship, he has filed a miscellaneous petition out of this present writ petition for a direction to the Honorable Court to be made to the school respondent to release his salary. Kindly see what a dubious role he is playing, writ petitioner here. Repeatedly. That is one. Let me verify one after another, Lordship. (267) of 2019. This case, which is today also it is enlisted. This case 267 of 2019 in writ petition 132. There we have given our reply. Our reply was filed on 29/11/2019.
What is this case about?
His action will be more visible.
So what is the?
This is the affidavit in opposition by the respondent number 10 on his behalf and also on behalf of the respondent number 9 and 11 on the application dated 16/11/2019.
What, Mr.?
Lordship, it is filed on 29/11/2019. The affidavit in opposition against this petition for releasing the salary.
This petition is for?
Lordship?
This petition is made.
Lordship, just
This is 267.
Your Lordship, may I just clarify a little bit? Lordship, may I clarify this matter? After challenging this...
No, clarification, please
Just-
note down.
just a moment.
Let me finish.
Your
You
Lordship-
clarify thereafter, not now.
Mr. Chaudhary, let him clarify. You have not been able to tell me what is this.
Your Lordship, in this miscellaneous application, how it is coming, just I will clarify. After filing this writ petition, because of I have challenged this order passed by the managing committee, they are not paying my current salaries. So, after a long period of time, when I am going to more sufferer, and petition was not hearing, petition was adjourned due to one after another reasons.
Yes.
So, Your Lordship, I have filed this petition, miscellaneous application, to release my current salary. So, after this court has passed the order, and based on the court order, then my current salary was paid and now also paid.
Okay, so this matter is over.
It is-
No,
it
Lordship,
is-
if Lordship hears the matter from the Shawkas here, the school filed, Lordship will understand what harassment his client was making.
Whatever the case may be,
Your
why
Lordship,
should you go into
Matter has been paid. Oh, everything is paid, Lordship.
Whether I can say it is really harass to me, because I was not...
It is not a harass. Your client was making harassing.
We'll see, we'll see who's right, who's wrong. Doesn't matter.
Lordship, nobody is wrong here.
You
If I am allowed, Lordship, I can say 10 letters were issued to him. Please come and collect. If you do not take, then money will be refunded. When this threatening government given, they refund the money. If this teacher is not accepting, then we wrote to him again that please correct it, otherwise we will have to refund. Then he came in and accepted. Otherwise, he was not doing it.
Anyway, that's beside the point now.
So this petition may be treated to have been disposed of. He has received all his payment.
That has been disposed of.
But it was incumbent on his part to file an affidavit that he has got his payment. There was a verbal direction to this writ petitioner that Mr. you give an affidavit that you have got the entire salary. He has not given any affidavit.
Anyway.
But I think my friend will now
he says he has got it,
that
so
he got the salary.
So that's all. No,
So this petition may be treated to have been
that is
ended, Lordship.
that is already
It's gone. So after that, there is nothing to be paid. What he has made a prayer in his present writ petition, what I have just submitted, that his actual hidden claim is that for his salary from 15/3/1995 to 1/3/2009, that he was not paid. So that the school cannot give, because the school gives according to the entitlement. Your Lordship, if your Lordship goes through the affidavit in opposition, in his page number, we have given a statement, Lordship, how the amount, what amount has been paid and what he has taken in between. There are other stories, Lordship. He has made a wrong with the help of one other school inspector advocate, one Mr. Khan, and went to directorate telling that I am the regular science teacher. But can't he show any single appointment letter that he has been appointed after his removal from service as per the resolution of the managing committee? He cannot show, Lordship. And there are also letters, your lordship goes through my rejoinder affidavit, that the government in its Department of Education, Directorate, has given a reply when he was approaching that please allow me to draw salary for the inspector of school. The director said that no salary is paid to the teacher directly. It is paid always to the school.
That is so. Yes, so anything else?
Lordship, I let me conclude, Lordship. Little remained. जो ये है ना जो जिसमें हमने ये दिया था रिटन आर्गुमेंट में जो कॉपी पे आया था ना, जो कहाँ है जो बन गया रिटन आर्गुमेंट, उसमें एनेक्शन ये भी दिया हुआ है. लॉर्डशिप, प्लीज अलाउ मी ए लिटिल टाइम. रिटन आर्गुमेंट जो हम बना के दिया था ना, मिल गया. Lordship, if your Lordship goes through the case record, Lordship will find that I have submitted my written argument as far back in 11th February 2019, because the case is coming at a hard job conclusion. Following day a new petition is filed, so it is lingered from 19 to 23 now. There, in this body of this, my assessment, conclusion, I said, the present writ petitioner is now working as science teacher for the respondent school against the second post for so transferred by the state respondent with effect from 1/3/2009, for which his salary are regularly being disbursed by the state respondent, and the respondent school is asking orally by way of issuing letters to him to furnish bank account number so as to transfer the same to his account as per the procedure involved, but the writ petitioner is not cooperating for the reason best known to him. In view of this factual position, legal position as stated above, the present writ petition is devoid of merit and deserves to be dismissed. In this writ petition, submission, Lordship, I have enclosed two Supreme Court's rulings. One is reported AIR 2005, Supreme Court 2911, where it is stated, Lordship.
Just AIR?
I have given, I will supply a extra copy I have taken, because I am sure that this has been somewhere misplaced. I have taken a spare copy for this honorable.
Just give the citation.
I am giving it. Kindly do not mind, Lordship.
You can give it later. Just give me the citation first.
I am giving. Number is that AIR 2005 Supreme Court 2911.
Para?
That is B. Vidyasagar.
Paragraph number?
Paragraph is 7.
7. Okay.
It goes like that. Constitution of India, Article 32, Power of Court. Petition involving factual controversy, requiring examination of oral and documentary evidence, not maintainable. Writ petition is not maintainable.
That is well settled.
Achha, there is another Lordship I am giving. There is one, this is AIR 2006 Supreme Court 198. Here it says, para 11, 14 and 15. It goes like the writ petition, Constitution of India Article 226, writ petition, money claim arising out of alleged breach of contract. This is, here we are concerned with only the principle decided, Lordship, not the fact. Money claim arising out of alleged breach of contract. High Court itself was observing that disputed question of fact were involved and yet went on to give direction as if it was adjudicating money claim in a suit. Such course adopted by the High Court is impermissible. Writ petition is not maintainable. So, as I was just submitting, Lordship, it is full of disputes, full of confusion, everything. So, this, first of all, the case should be dismissed on the principle of res judicata, as I have just submitted on the first round of decision and the second round, res judicata. Secondly, it is barred by estoppel once he has acted upon and worked 13 months, and hardly now the present writ petition. So, this is a very nice case to be dismissed on this ground of estoppel.
Is it always nice to get your case dismissed?
Lordship, I tried my best to impress upon the Honorable Court to say, I think real justice will come from the fountain of this Honorable Court. I pray to God, I think it will come.
Yes, I think we can.
Much obliged, Lordship.
We can ignore your rhetoric. Yes, Mr. Padia?
Lordship, I'm for the respondent number 12.
What is your role here actually?
Lordship, my role is that only to state that I am the regular science teacher and pursuant to order.
What is your, is there any appointment order, sanction order?
Lordship, I supply one dates and events, Lordship.
Lordship, should I give
So,
my...
Yes, you can do it later.
But if there is some marking here and there, kindly don't excuse me for that.
You give a better copy.
Please give it. No, this is the... please give it. It is just if your Honorable Court does not get the original one, then please take help of this. This will give the entire picture, Lordship.
Yes.
Judgment copy also I have enclosed.
Respondent 12.
Such volume of papers.
Please, Lordship, here the initially, Lordship, the present petitioner was appointed as a science teacher, which is clear from this list of dates and events which I have supplied to Lordship. On 7/8/1994, by the resolution of the managing committee of the school, he was appointed, and that appointment was temporary, Lordship, purely temporary. And by resolution 15/3/95, another teacher was appointed. His name is Samul Raja, a science teacher, with a direction to the secretary to allow the present petitioner Imam Muhammad Abu Alam Abdullah as additional teacher, or to serve him the notice that his service is no longer required. At that appropriate relevant point of time, he was silent. He had accepted as an additional science teacher. Then he was working, and the appointment of the S. Raja was duly approved. And then S. Raja was receiving the grant, science grant, from 1/3/1995 to 28/2/1997. Point number 5. The next page. In 1997, Lordship, S. Raja had got a job somewhere else and he had resigned. And it was at this relevant point of time that the MC had requested that the science grant should come into the name of the present petitioner, writ petitioner. And it was purely at the request, and his appointment was not regularized. And 17/11/1999, respondent number 12, Srimati Ismatara Rahman, was appointed as a science teacher in the school. And her appointment was also not challenged at that relevant point of time. 18/11, respondent number 12 has joined the school. 12/1/2000, the inspector of his school approved the appointment of respondent number 12. Now 8/4/2022, the headmaster cum secretary of the school had conveyed to the respondent number 12 that inspector of his school was Garoj Tura approved her appointment, and proposal for sanction of science grant was also made. 19/4/2022 or 2002, headmaster cum secretary, after the proposal was made for science grant in the name of the respondent number 12, the service of the present writ petitioner was terminated. 19/4/2002, which is page 72 and 73 of the compilation. Then in May 2002, the writ petitioner has filed a petition, approached this honorable court, filed a writ petition which was registered as WPC number 168 SH of 2002, and got an interim stay against the termination. At that point of time, the school had decided to terminate my service. Then I had also approached the honorable court by filing a writ petition, that is WPC number 185 SH of 2002. And both the writ petition were stacked together and decided by this honorable court by judgment and order dated 28/3/2006.
Yes.
28/3/2006, both writ petitions were decided, and thereafter the state has preferred an appeal before the division bench against both the writ petitions, and those were registered as WA number 14 SH 2006, where present respondent number 12 is a sole respondent, and WA number 15 SH 2006, where the present writ petitioner was the respondent, and both the writ petition were dismissed by order dated judgment and order dated 1/5/2008. Now the direction of the single judge was that both the teachers to be accommodated. Now, so there was delay, and then the present writ petitioner had filed a COP, contempt petition, which was registered at 9 SH of 2009, which is 126 of the compilation, page number 126 to 128. In that, while making the submission, Lordship, it was stated that the contempt is only relating to 185, while the order, common order, was for both the writ petition 168 and 185. And during the pendency of that contempt petition, Lordship, the one post was sanctioned to that school additional, and that will remain till the retirement or their resignation.
That letter 336/2009.
Yes, Lordship, 2009. And then the present writ petitioner has also filed one writ petition. After that, Lordship, there were sanctions were in the name of the respondent number 5 in that writ petition. That means the present writ petitioner. So in the year 2009, I have also filed a writ petition that was numbered as WPC 247 of 2009, claiming that I am entitled for that amount. And in 2010, the present writ petitioner had also filed a writ petition giving the number of periods, giving the period 1/3/1997 to 2009 19/2009 that he is entitled to.
Yes, for all these periods, yes.
Yes, and both the writ petition was tagged together, and the Honorable Court, by order dated 14/2014, disposed of both the writ petition with the order that they should be paid as per their entitlement. Thereafter, the school authorities and the irrespective of school together had taken some decisions and were making the payment to the respondent number 12, which respondent number 12 is to say, and the post created transferred one sanction force which was transferred for Denny Linda. In that post, the present writ petitioner was absolved. And yesterday, Lordship, while referring about the page 158 of the compilation, that the star mark was given in respects to Srimati Ismatara Rahman. And with a note, that is the contention of the petitioner. That a note is also given at the side. Side note is there.
Yes.
The one post is personal and will be till retirement of resignation of the present petitioner.
Yes, this Tano is, you see, this is
for both.
This is
for both, because
no, one post it says.
One post is there.
But this is not, you see, actually this star mark doesn't mean
yes
against this number 2.
That it is against me. And 122 of the writ petition.
No, this is not against you. This is an observation made in that order dated 3/6/2009. When that post was transferred, it is personal to the petitioner.
Petitioners.
Not respondent.
Yes.
Sure. Anyway.
And 122 makes it clear, Lordship.
Yes.
Of the writ petition.
That's what I said.
That is for the present petitioner. So therefore, the claim of the petitioner that he is entitled only is not maintainable. Only that much, Lordship.
Yes.
I will just rely on the submissions put forward, my lord. My initial effort was to establish the position of the writ petitioner. It seems after the submission of the managing committee and the respondent number 12, my lord, the position of the writ petitioner is made very clear, my lord. So I rely totally on them. And
you file your.
I have filed my counter affidavit, bringing in many things, my lord, and I am also filing the written submission today, my lord. The written argument of the.
You have not filed.
No, my lord. It seems I have not.
Because you see, this court would like to know from you. You see, the appointment order of the petitioner, appointment order of the respondent to us. Because the process is very well known to you. The managing committee will recommend, and the government will approve.
Yes.
Such recommendation. So upon that approval, is it on record?
No, my lord. We have not brought it in our counter affidavit, my lord.
But it should be there.
It should be there. It is a matter of record, my lord. So from the parties' pleadings, it will be there.
No, but
it is there, my lord. It is there, my lord.
I have mentioned in my all the replies in the rejoinder affidavit, affidavit of opposition, affidavit of facts. I have given. If these are gone through, Lordship, every answer is there. Lordship. Every answer is there. 3 and 4 sets of petitions and reply. Lordship.
So, Mr. Senugupta,
yes, I conclude my.
So I'll give you 2 weeks, 1 week to file your.
I have already finished my.
Oh, you finished?
Yes.
File it in course of. Oh, you have done it.
This one copy may given to me.
No, the same copy given earlier. Just for the record purpose.
It is given already.
Yes, it's already given.
If it is given
already. First, you say you have not.
Yes, officially. This is a written memo, my lord. Just to establish the position of as an addition science.
So, Yusuf, just to sum Not again, just to give some reply on the submission given. Is it?
Well, it's concluded again.
Because one aspect of matter, you see, the managing committee has referred the judgment. These are the judgment not related to the pertaining to the salary, and it is pertaining to contract, and this is also in commercial contract. So had it been this dispute fact, it is not applicable in the present case. It can be relied upon. And as regard to this submission made by the state, you see, my reply on the basis of it, you see, the state has taken the different stand, and I have taken the stand in my affidavit also, that they have given the false statement before the Honorable Court. Because of it, you see, the already I referred, page number 96, that even 2004, when this respondent number 12 approves for the salary, then Director of Education has clearly stated that if any person is appointed by the managing committee, payment should be given by the managing committee in the 2004, prior to the writ petition being decided. So in such situation, you see, prior to the writ petition decided, up to 2004, the state government was not having any record about the appointment of the respondent number 12. It is clear. Page number 96 in my compilation I have given. And another aspect of the matter, you see, Land Council already argued, and then saying about the res judicata. It is not the case of res judicata. And another point of this, you see, this stated that already I filed the petition, and in this petition, petitioner disposed to make payment as per entitlement, and I went for the review petition. This is correct to say, you see. So when this review petition was dismissed, that it seems to be good thing, this seems to be appeal. Then I didn't went for appeal. So subsequently, when I came for the content, on the basis of the writ petition filed by me for the entitlement, not for the review. So when review is not considered, then my writ petition, it is not the writ petition been dismissed. So it was subsequently when I filed the contempt petition. In the contempt petition, they came forward and then make payment. So prior to this, when the court is given, if any clarification required, I have to take clarification from the court. So when I am very much sure, Your Lordship, that whatsoever order has passed, it is not in conformity with the entitlement of mine. So I am having the option to come to the petition, Your Lordship. I am challenging this order. I am not coming to this order whether this order was correct or not, order passed by the single judge. This is not the. This is the fresh cause of action when they have given. And here in my petition, I have given as per my entitlement. And each and every order it is given, the name of the teacher who are given in the order, he should be make payment. So you will see my case is that I have given the orders of this director of the education passed from time to time, and based on this I have raised this claim before this honorable court. So there is no dispute of fact, and if it is dispute of fact, neither managing committee nor the state has stated that the order whoever I have given as a proof of it, it is not correct. And even in the matters of after transferring the post, I have given in my compilation also, when this post was transferred, and after this respondent number 12 was paid, first of all 15,000 out of 18,000, because transferred, and after this it was a little bit less. Then after this another 3,000 given, and accordingly 21,000 has made payment to the petitioner. And in my order, it is clearly given 18,000 for the period of 1/3/2009 to subsequently. So you will see, it is crystal clear that post was created and it was given equivalent to the respondent number 12. And here you will see most this I have given in this in my affidavit already there, and it is there. So it was been transferred from the another school. For the school it is, but it is transferred from the another school. So you will see here in this case, the respondents tried to confuse here, first of all, that I was appointed and I was terminated.
You make your reply on law point, Mr.
No, law point.
And you don't start afresh.
I am not trying this. Just
Then
I'm
I
giving.
will have a sub reply against that. If you start afresh, again history, No,
So you listen, you listen, legal points I'm saying. I'm saying legal points. Legal points, if I didn't fact about it, what legal points I'm
already been said.
So you listen, my legal point is there. Is there any rule that if the person is appointed and managing committee can appoint another person without following the due process and replace me? This is the one legal point. Is there any rule they have produced?
But you have not challenged that.
So you listen, because this is the matters already when it is come in 1/3/1995 on the basis of this order, they again terminated me in 2002, and in this order they have mentioned. So when I have came to know and my termination was there, I have challenged the order of the termination about 19/4/2002, and this has been already decided. So when it decided, then 15/3/1995, whatsoever order passed, they are no longer. And even in the court, it is in the High Court judgment is a single bench. It is even paragraph 6. It is stated the position of mine should have continued. They may consider as a break for the period when this project was appointed, if it is admitted. So in such situation, Your Lordship, and subsequently they have taken the grant in my name. So legal position is there, Your Lordship. When the
Grant
government
taken falsely.
You show me the false.
It is replied. Show means it is replied. It is replied in my.
Yes, just a moment, please, Mr.
If it is,
Don't
if it is
do
false.
this. You must
Your
start with
Lordship,
your first lordship.
Your Lordship, I am seeing the
I've
legal
got
points, Your
objection,
Lordship.
We have already concluded, my lord. It is all.
Your
Last
Lordship,
time also
Your
he
Lordship,
has
the
in
legal
that
points.
way
What's the
given
legal
the
points?
matter.
Legal points is that if they are saying, Your Lordship, that if it is done,
Say
they should
means
show.
replied. It is there.
Just a moment.
Your Lordship, I can say so many matters, but legal point. What is the legal
You have
points? Your
finished.
Lordship?
2 days you have taken.
Your Lordship, if this were interrupt, Your Lordship.
Right, but it's not called interference.
No,
You
this
should
is
have gone.
the intentional deliberate find the managing committee
you
law
should have
council.
gone
Sir, senior
special
council should
special
have
leave
maintained this
application
dignity of
against
the
review
court.
petition.
You know,
Against
see,
the
senior
review
council
petition
should
when it
maintain
is
the
lost.
dignity of
You
the
should
court.
have gone to Supreme Court. Not here.
It is my submission is senior council should maintain the dignity. We should learn from the seniors.
No, please don't raise your voice.
You know, see, this is the way. This is the way. When I am just clarifying some matters, legal points. How to the legal points? You know, see, when the matters has been disposed of by the court, can again we hesitate? You know, see, I didn't come for this challenge of this court because already we decided. Already decided, you know, see. When they already decided by this court, then why are you coming again?
See, those are just reference made.
That's no, you know,
reference is made to certain orders. Reference is made to certain matters which has already been disposed of. It is just a reference to understand the situation as it is now.
Yes.
You have stated
another legal point.
As far as your petition is concerned,
yes,
you are confined only to
as per government order.
Yeah, for your dues which have not been given to you.
Yes, yes.
So in that context, the matter will be examined.
Yes. So here you will see another aspect of the matter. You will see.
We cannot go back to what is what.
No, legal points. You will see another point. When this CAP 9 has come up and heard before this honorable court, so after the order passed, then it was knowledge of the managing committee as well as to the respondent 12, and the state is given. None of them has come for petition against this order. So it is in the finality. So if the court orders pass and nobody is challenging about it, you see. So when in contempt court order has been passed, that 185 has been accumulated, you see. So now at the stage, you see, they cannot say it is.
That is only for the creation of the post.
No, this is the you see, legal points.
That has been done. That has already. So page 122 has been has answered that.
So you will see this here you will see just I am saying this is the legal point. Once it is given, then we cannot even say that this is not the legal position.
You have covered all that in your.
Yeah, you will see all these matters in my compilation. There you will see.
Right.
And then here basically I have given you this matters how this they make payment and what is the difference. Only this much.
Right.
And due to this you will see. My learned friend is given this as a res judicata. It is not that.
That the court will decide. So about the parties, judgment is reserved.
Supplementary cost list number 1, item number 1.
Yes, Mr. Panthi. Tell me.
My lord, I have come with a limited prayer. Madam, kindly come to page 8, Lordship, Annex 1.
Yes, who's appearing for respondent? Page?
Page 8, Lordship.
Yes.
The operative portion will be at page 9, Lordship. If I may read, Lordship.
Yes.
Accordingly, the accused person ever named is hereby directed to be enlarged on bail for an interim period of 1 month to allow the family members to get him medically treated at any private facility of their choice within the state of Meghalaya. In view thereof, my lord had imposed these conditions. And my lord, may kindly come to page 10, para 6. It says, my lord, at the end of 1 month's period from today, the accused is to report before the jail authorities, my lord. So this was the directions issued by this lordship, by my lord. So thereafter, my lord, we have consulted few medical experts, and finally, my lord, we have gone to Nigrims. We have got our the accused person has got himself checked, my lord. Then thereafter, my lord, I have enclosed various certificates. If thereafter, my lord, after the test being carried out, I may take the lordship to page 23, lordship.
Yes.
My lord, after those tests and reports, doctor has advised my lord rest for a period of further 1 month, lordship. And also, my lord, he has advised my lord to follow up after a period of 1 month, my lord.
Where is the?
It's at the bottom, lordship. At the bottom, lordship, is at page 23.
Yes.
So, my lord, in this view of the matter, my lord, I'm just praying, my lord, this interim bail which my lord has granted may kindly be extended for a further period, lordship, considering his health condition and for his betterment, lordship. I'm just
This is case under which provision?
My lord,
Yes.
NDPS, lordship.
21B and 29 of NDPS Act.
In fact, my lord, even the accused person also have been in custody for my lord more than 6 months, lordship.
What is the stage of the case?
My lord, matter has already been charged sheeted, my lord, and then it is.
The trial has not yet begun, my lord.
Trial has to begin. My lord, it seems accused person he is suffering from asthma, and he was not admitted in the hospital. This document shows it's OPD. He has gone to the OPD and have done his checkup.
In this regard, my lord, the doctor has advised that you can take rest at home, and you can come and visit the hospital when it is required. That's what advised, my lord. As per that, my lord, he was not admitted, my lord.
Here, my lord, the contraband seized is 140 gram, my lord, that is intermediate.
In any case, Mr. Silkon, see, matter has been charged sheeted.
My lord, that is true.
So, investigation is no longer required. Yes. Custodial, interrogation is no longer required.
It's up to
it's pointless to keep him in jail. But Mr. S. Panthi, Lawyer Counsel for the petitioner, who has submitted that this court, by order dated. Where is that order?
My lord, is it page 8, lordship?
Order
dated 4/9/2023, lordship.
4/9/2023 in BA number 39 of 2023 has allowed the prayer of the petitioner therein, inasmuch as the accused person connected with
Nongpo PS case number 31/2023, Lordship.
Nongpo case number 31
31/2023, Lordship.
2023
Under section 21 bracketed B/29 of NDPS Act.
under section 21B, small b, oblique 25 oblique 29 NDPS Act.
29.
29.
That's it.
Kumunto. Has been.
My Lord, may I just intervene? This case, after my Lord charge sheet, have been renumbered as
Yes,
special case number.
that I will,
Lordship.
has been allowed to go on interim bail for the purpose of his medical treatment. The Learned Counsel has further submitted that accordingly the accused oblique patient has gone for treatment at Negrims. Upon on being treated and consulted at the Negrims, the attending doctor has given his opinion as on 27/9/2023 that the patient, that is the accused, is advised rest for 1 month and that he is to visit the hospital as and when he is required. The said advice of the doctor at Negrims has been annexed. A copy of the said advice has been annexed at page 23 of this petition. It is therefore the prayer of the Learned Counsel that the interim bail may be extended for a period of another month. Mr. Ensirko Larat has, appearing on behalf of the state respondent, has submitted that in the meantime the charge sheet has been filed and a case has been registered as being a regular case has been registered being, what is the case number?
10, Lordship. Special NDPS case number 10 of 2023, Lordship.
Special NDPS case number 10 of
2023.
Before the Court of the Learned Special Judge NDPS at
Nongpo, Lordship.
Nongpo, Aribhoi District, Nongpo. The GA has accordingly left it to the discretion of the court to pass necessary orders on the basis of the document and the submission made by the petitioner. This court, on consideration of the submission made and on perusal of the said medical papers, has noticed that the accused patient was indeed advised rest for 1 month it may not be out of place to mention herein that in the meantime the case, the charge sheet has been filed in the case, and as such custodial questioning or interrogation of the accused is no longer required. He is to face trial in due course, be that as it may. On grounds of be that as it may, considering the fact that the accused patient is required to go for further consultation at the NIGRIMS, the prayer for extension of the interim bail is allowed. The accused person is allowed to go on interim bail on the following condition, on a condition specified on the following condition, that he shall not abscond or tamper with the evidence or witnesses, that he shall not leave the jurisdiction of the state, and if required to do so, the same should be with the prior permission of the trial court. And in the meantime, as an interim measure, he shall bind himself on a personal bond of 50,000 with one surety of like amount to the satisfaction of the trial court. The petitioner is also directed to report to the nowadays we don't call it jails, no? No. It is prison, to the prison and correctional home on expiry of 1 month period from today, that is on, how do we count? Today is 4th, so 5th November. Obligation disposal.
Sunday. My lord, I think 5th is Sunday, as my learned friend has said.
So Sunday he cannot go.
He can go. He can go. He can go. He can go.
Unless he wants to go to church, then I'll allow him.
He can go. No problem. I just highlighted this on prices on code. That's Sunday. No problem. We'll go.
You see, it's not a question of going to office or something.
Yes, yes, Lordship.
You can go.
That one will be district prison and correctional home, madam.
Yeah, district prison and correctional home.
In ROC meter, I was not in a position to. I was in another court, Your Lordship.
Yes, I have already passed the order.
Your Lordship, I beg apology, Your Lordship. This manner was.
But my lord, one small aspect, Lordship. Here, after the expiry of 1 month, my lord, I have been directed to report to the doctor again. That is there in the, my lord, the prescription. So my lord if he kindly grant for the period, that would be, my lord would be very pleased, considering the health condition of the accused person, my lord. That limited prayer, my lord.
When was the last visit? That was
last visit 27th, Lordship.
27th? 9. So next visit will be 20. After 27, 9?
Yes.
Oh,
it's
that will
fine.
cover.
It's fine. So Lordship, I am sorry, Lordship, just I because when ordering the Supreme Court and that I feel so bad. We are hearing this court, Your Lordship.
Thank you.